Hey, I'm going to do a real short live. It is Monday evening, May the 6th. And I had posted earlier, I have got this is going to be a really rough week. I just had to share a couple things though. So I'm just going to do a quickie here, let you know what's going on, and read something to you that I ran across. So just let me tag a couple people, wake some people up here. Everybody goes like, okay, it's Monday and Connie's on live. Thursday, Monday, Saturday. We never know when she's just gonna like go, okay, time to talk. I hope some of you were able to catch Saturday. I had a really nice interview. BJ Edwards took me on his show. We posted it a couple times, and he has a little bit different audience, so I'm always happy to do that, to touch on to some other people. I've seen a lot of people posting some details about what's going on with you individually. I want you to know I really appreciate that. I love hearing details. I'm sorry if that makes me sound weird, but I like to know the details of what's gone on. And, and of course, that's one of the things that I'm trying to do is train everybody, like, get your details, write them down. It's so hard to even keep up with them. I mean, even on my own cases, because there's something happening every freaking day. Oh. All right. So, great. Okay, so just a couple of things. One of them I wanted to share with you. It's going to be a year to shake up the First Amendment, obviously. So the disciplinary board has come after me for First Amendment issues because I've spoken up in certain forums. There were some parents that were complaining about a judge, and I said you can always go to the commission, so we went to the Williamson County Commission, and now all of a sudden I should be sanctioned or disbarred or cut off because I invited people apparently to an audience that was critical of a judge. Now, mind you, this had nothing to do with any particular case that was pending, and I'm known to be an activist. I get out there, I talk about DCS, about what's going on in these courtrooms, and everybody knows that. So this is going to be a real interesting First Amendment battle. I spent the weekend pulling a ton of First Amendment issues related to attorney speech, because everybody goes like, why won't attorneys speak up? Well, they're scared to death to, because it's like, if you say one bad thing, you are going to be sanctioned, it's just crazy. So it's going to be a First Amendment year, I have a feeling. I don't know if any of you saw, but I did share a post from the Tennessee General Assembly. They apparently had a big brouhaha downtown today. The Speaker of the House, our new Speaker, Glenn Cassida, was accused of being a racist and locked the doors to the room. I'm just going to tell you, this is what's so weird about that. So when I heard, the House floor, it's like the doors were locked. I'm like, that's weird. I'm like, really? We're down to that? We're down to locking legislators in a room or out of a room? And I'm going to tell you why that just shakes me back about 10 years, because about 10 years ago, there was probably a little longer than that, probably about 2008. So that's that's about 10 years ago, I guess. Very heated judicial race in my county. And a part of the issue was about the morals of one of the judicial candidates, and there had been some, depositions and testimony spread around through the bar. Really, it wasn't lies, it was all true. And so after the election was over, another judge, on a motion docket, locked all the attorneys in the courtroom. I kid you not, locked all the attorneys in the courtroom, and then gave us this big lecture about basically you shouldn't be saying bad things about judges and attorneys. I'm like, this is just weird. This is so weird. But that's really the environment, and it's just, grown and grown. And I spoke up in many forums with lots of different people, and I want a better system. So So I want to share with you a little bit about this case that somebody, let's see, when did this case get filed? April the 19th. It was filed in Tennessee, down in Chattanooga area. It's just amazing. I mean, you know, they talk about criticizing the government and criticizing judges, and it's like, if you don't do it, if you don't have the freedom to be critical of the system, of systems, because it's not, I mean, the sheriff's departments and jails and, you know, all those things are sued all the time. And so if you, and the systems are just so broken. And I just got to share with you a little bit about what was going on down in Bradley County. A couple things got shared to me about Bradley County today, but Bradley County is down close to Chattanooga, just a little bit north of Chattanooga. I've actually worked down there a little bit, and I think one of our state reps who was a judge down in Bradley County, I'm pretty sure that's where he was from. Listen to this. This is about a guy who went to jail. He was on meth when they got him in jail. They put him in the shower. They admit the guy couldn't stand up. He couldn't read. I mean, he was just like, he was a mess. And he died because they didn't get him any medical treatment. And so they've been sued. And it talks about how they've had a high number of deaths in that jail. But let me tell you about the sheriff. Here's what this complaint says about the sheriff. It says, Watson, who's the sheriff, often left the jail in fearful neglect, willfully oblivious to its severe problems. Now, I just want to ask you, if I said that about the operation of a certain courtroom, if I said that the judges were operating in fearful neglect, willfully oblivious to severe problems in the courtroom, what do you think would happen? Oh, they'd be all over me. Anyway, this is the sheriff. You say it about the sheriff. Why can't you say, who are law enforcement? Why can't you say it about the functioning of the judicial system? Okay, so to go on with this, it says, as a distracted sheriff of a burgeoning Tennessee county, Watson expended major official time and energies either fending off lawsuits and criminal indictments or running for re-election. Only in Tennessee. While sheriff, Watson directed substantial efforts to moonlighting as a car salesman or promoting his wife's bonding business, both of which profited him immensely, though each took him to the brink of illegality, if not deep into it. While sheriff, Watson once sold used cars straight off the municipal parking lot of Benton, Tennessee. Many times, his wife attended DUI roundups with the sheriff with bail receipts in hand. Yeah, that's Tennessee for you. So the sheriff is selling cars off the municipal car lot. His wife's operating a bail bond company, and she's driving around with them while they're making stops and DUI arrests so they can write bail bond receipts. Yeah, while they're running for sheriff. So, and I'm just going to tell you, it ain't just sheriff's departments. I mean, they go on in here to talk about the low funding of the Quality Correctional Health Care Company that was supposed to be providing health care services. And it talks about the previous deaths they had. It says past incidents of this nature, no matter how deadly, had no effect on them, had no effect on making any improvements. Yeah. So I am traveling tomorrow up to Cincinnati for a Sixth Circuit argument on a federal case that I've been working on a really long time, actually. Can you get a copy of that report? Yeah, Mary, I'm going to tell you. You can Google this. I'm going to tell you what it is. It says, lawsuit says Bradley County inmate who was falling down, sweating profusely, and unable to walk died of neglected care. This may be backwards. Can you see that? You can probably find this. The name of the case is Estate of Brandon Gash, Gash, by next of kin, Harry Gash and Cheryl Gash, v. Bradley County. So it is United States District Court, Eastern Division in Chattanooga. Yeah, I'll show you that one more time. Here, put this up there in case you need to stop the film. This may be backwards. I'm not sure if you can see that. That's the case. There's a case number. So anyway, so I'm traveling to Cincinnati. So it's about a 6-hour drive up there. So of course I have to go the day before because court is at 9 o'clock in the morning. And I get up, I'll go to court at 9 o'clock in the morning on Potter Street in downtown Cincinnati. I get 15 minutes to make my case. 15 minutes, and then I drive 6 hours back. Yeah. So fortunately, someone's going with me, so we'll have some time to brainstorm, go back and forth, but I'm just telling you, 15 minutes ain't very long. So I've got to get my arguments squared on. It's all about the treatment of a juvenile in juvenile detention. It's a very important case, very important. All right, and so I also want to let you know I had a conversation with somebody today. And I'm not going to name any names because I want us to be able to work on what we're doing and kind of figure out where we're going to go. Some things gel and some things don't. I talk to people all the time. And after it is heard at 16:30. Oh, okay, James, I'm not sure what that comment was about, but... And so we were just talking about parents' rights within the educational system, and I'm going to do a little bit of research on that. But, you know, I talked about it's the same thing. You know, we have this new horrible, horrible law that just passed in Tennessee. Thank you, Crystal. I'm trying to figure out how to raise some cane on it, but I'm going to tell you once again, if you haven't heard before, Tennessee just passed a law that if there is an open CPS investigation and you change your child's school enrollment, so let's just say you decide to take them out and homeschool them or, you know, move to a different county, the parent can go to jail. Okay, it doesn't. Now, that's just an investigation, all right? Now, that's not an adjudication. That's not having been found guilty, okay? It is just an investigation. So, you know, and this is something, these rights that are stripped away from parents before they're adjudicated as having done anything wrong is happening all the time in these dependency courts. And I know, you know, I did one story. I saw Dennis come on. I'm not sure if he's still there, but, you know, we did a story about drug testing in one county where, you know, you just walk in the door and the judge goes, you need to take a drug test. And I'm like, no, you know, there's a Fourth Amendment violation there. These urine screens that DCS does are not reliable anyway, and there's no basis for it. That is a Fourth Amendment violation. Now they can go start an investigation and you can't stop them. And they can drag your kids out. Now, let me tell you, you know, people go like, well, you know, they just need to be able to investigate. They just need to be able to investigate. Now, they'll probably bash me on this too. They're going to say that I don't care about child abuse investigations. Look, if there's an allegation that a child is injured, they can get the child, okay? Otherwise, they need to follow the law. They need to follow the law. This is one more advancement in violating parental rights. The rights to the private, your right to family integrity, your right to privacy, your right to not have your kid pulled out of class and stuck in a private room and interviewed by somebody that they don't even know. And I had a parent come to me about 6 months ago, and she was from a different county. and she had a child, and the abuse allegation was not even on her child, but on her stepchild. And they went to school and they pulled her child, who was about 10 or 11 years old, out of class like 4 times. And they would never close the investigation. They just kept going back and talking to her child. And they were having anxiety. They didn't know what was going on. The parent went to the school and complained, and they didn't get any relief. All right, so this law, now let me tell you about this law. So this law passed. It passed the Senate floor March the 14th. March the 14th. It just passed unanimously. 27 senators said it's okay. 27 senators. Unanimously. Not even a blink of an eye that this could be unconstitutional. April 30th, it passed the House unanimously. Not even a blink of an eye on the House floor, after we had passed out flyers to every single member of the House that this was unconstitutional. It is horrid. It's horrid. It's one more step in stripping your rights to privacy, your rights to family integrity and freedoms. And they're doing other things at the schools too. They are, they have this program in Tennessee called STARS, and they are counselors in the school. And those counselors can call your child in without your knowledge, without your consent, and can interview your child, can give your child assessments such as anxiety assessments, abuse assessments, depression assessments. They can do that to your child. And they have no obligation to tell you, no obligation to get your consent, and no obligation to preserve those records. Okay? So that's kind of where we are, right? Just so you know. All right, so I'm going to, and I'm just going to tell you again, this year, First Amendment is going to be a big deal. Yeah, it is. So I'm going to tell you just a little bit of the law. There's a case called Garrison v. Louisiana. And Garrison v. Louisiana is a case basically about sedition, about criminal sedition. And, there were criminal sedition laws in the United States shortly after the Revolutionary War, because here we were, we were revolutionaries in this country. All these people had fought against the Brits, which was our government, right? The British government was here controlling us. And so the Revolutionary War were people who spoke up and fought the British government. So once we won the Revolutionary War in late 1700s, probably very end, like maybe the very beginning of 1800, they passed sedition laws in the United States. Sedition, so that people could not speak badly about the American government. And if you did, you could be incarcerated. Okay, that's called criminal sedition, right? So they had passed these sedition laws. They were on the books for a really, really, really long time, right? And so finally, and I'm sorry I cut the date off on this, but it didn't, it was sometime in the 20th century that they finally got a case all the way to the United States Supreme Court fighting criminal sedition. And especially when you are talking about public officials and the business of public officials. And it says, finally, the United States Supreme Court said, hang on here. Okay, so, it says a knowing false statement made with, false statement made with reckless disregard for the truth does not enjoy constitutional protection, but the court does so only by risking the robust debate of public issues that is the essence of self-government. Moreover, even where the utterance is false, the great principles of the Constitution which secure freedom of expression in this area preclude attaching adverse consequences to any except the knowing or reckless falsehood. Debate on public issues will not be uninhibited if the speaker must run the risk that it will be proved in court that he spoke out of hatred. okay? This is the development of our First Amendment rights, okay? This is the development of our First Amendment rights. And this was about the criminal libel statute, all right, basically. And hang on here, I wanted to go a little bit further. It says, where the criticism is of public officials and their conduct of public business, the interest in private reputation is overborne by the larger public interest secured by the Constitution in the dissemination of truth. The court in Garrison further recognized the paramount public interest in a free flow of information to the people, to the people concerning public officials, their servants. To this end, anything which might touch on an official's fitness for office is relevant. Let me say that again. To this end, anything that might touch on an official's fitness for office is relevant. Few personal attributes are more germane to fitness for office than dishonesty, malfeasance, or improper motivation, right? So all you parents and families out there that are being impugned for speaking about public officials in the performance of their duties, I've got another big long brief I wrote from a case by the ACLU that you have a right to record and disseminate public officials in their work, okay? They are your servants, all right? When a DCS worker comes knocking on your door, right? They are a public servant. They are no longer working in personam. They are working as an agent of your tax dollars, okay? Remind them they are an agent of your tax dollars. They do not like that, okay? Bureaucratic employees and attorneys don't like to be confronted with the fact that they are your employees paid by your tax dollars, okay? They forget that. So if they are working as a public employee, what they do is a public interest, which supersedes the interest of any one individual. All right? Yeah. Okay, you guys. I'm looking at some of your comments here. Okay, so that's really all I'm going to go over tonight. I've got to get ready, do some reviewing, do some reading. I read, as you probably know by now, prolifically. Probably for every one case that most attorneys read, I've read 10. So I pulled a bunch of First Amendment cases, got buried deep inside of them over the weekend, and so we're going to have some First Amendment fun this year. So stay tuned. All right. In the meantime, got some 14th Amendment fun that's going to be coming up too on due process, integrity, etc. So remember, it's your family. Protect your family. Keep good records. Y'all have phones. Keep notes in your phones. Take photographs. Do videos. Notes. I mean, they are so incompetent in what they do, and it's going to catch up, all right? But we got to stay on top of them, okay? All right, y'all, good night. You have a good evening. Love you. Talk to you soon. Bye-bye.